coming from the top court of the country that has now ruled greater restrictions will not be imposed on freedom of speech of ministers, MPs and MLAs. The Supreme Court was looking at a case that wanted hate speeches or other speeches by lawmakers and politicians to be curtailed, but a 5-judge bench has now said Article 19 is sacrosanct. They've also said that the restrictions in it are exhaustive. The details coming in as the 5-judge bench is on our screens, viewers. Today, a top court judgment coming that the greater restrictions will not be imposed on the freedom of speech of ministers, MPs, MLAs. The Supreme Court ruling very clear with what they had said earlier. The question they had to decide is whether restrictions can be imposed on public functionaries. A 5-judge bench was hearing the matter. There's a dissenting opinion by Justice Nagaratna, but all 5 of them, Justice Abdul Nazir, Justice B.R. Gawai, Justice Bopanna, Justice Rama Subramanian, who has pronounced the order for the 4 judges, has also come out. The case was relating to a hate speech allegedly that had been made by UP Minister Azam Khan about a rape case, and he had subsequently apologized for his words when he said there was politicization of the rape. The Solicitor General appeared for the centre. He basically stated that there should be no more restrictions to be placed on the freedom of speech and expression, even of public functionaries including MPs, MLAs and ministers. Earlier also this matter was heard, and now for the petitioners, they had stated that there should be a constitutional culture that should be there, that they should be speaking in minutes. Supreme Court minister's statement can't be attributed to the government. They say there is no need for greater restrictions. I also want to go across to guests who continue to be patched with us. We have Karan Verma, author and political analyst, and we have Ashwini Dubey, advocate on record from the Supreme Court, joining us on this. If I can actually come across and go to you, Ashwini, a good judgment coming from the Supreme Court that has refused to say that we shall put more restrictions on the freedom that is there. Article 19(2) is exhaustive, and that's how this case should have actually progressed.
Rhythm, for having me here. Rhythm, the question was that whether Article 19(2) relates to the power of a state to make laws imposing reasonable restrictions on the exercise of the right of freedom of his speech and expression in the interest of sovereignty, integrity of the country, public order, decency, morality, and that too, when a person having a constitutional post, does 92 become more applicable on him? The Supreme Court has now ruled that, look, the additional restrictions not found in Article 19(2) and henceforth cannot be imposed on the exercise of right to free speech under Article 19(1)(a) of anyone who is having the constitutional post or the dignitary or the minister or MP or MLA. So Supreme Court found that the ground mentioned in Article 19(2), as you rightly said, that for restricting free speech are exhaustive. While the court agreed that the fundamental right under Article 19(1)(a) can be exercised even against the instrumentalities other than the state, but it added that a statement made by the minister inconsistent with the rights of the citizens may not be actionable as a constitutional tort. But Justice Nagaratna has also pointed out that we live in a constitutional democracy. But at the same time, the Supreme Court does not say that if it is attributable to be any offense, then the subject to it will be the subject to the law of the land. But so far as the rights given under Article 19(1)(a) of the Constitution of India and vis-a-vis restriction imposed under Article 19(2), there is no restriction, there is no additional restriction vis-a-vis for making any statement which is permissible within the law, be it the common man and be it a minister or a constitutional authority. Over to you.
Absolutely. I also want to go across, and before I do to Karan, I just want to tell our viewers what's really happened today. A 5-judge constitutional bench has ruled there are no additional restrictions that are needed. This is even for those that are lawmakers, politicians, etc. The Supreme Court today says that a minister's statement can't be vicariously attributed to the government, Karan, and the minister is liable for the statement itself. They've also, Karan, added a very interesting thing that public figures must watch what they say.
Yes. Rhythm, I agree that the list of Article 19 subsection 2 is very exhaustive. I mean, it includes everything, whether it's public order, morality, defamation, incitement to offense, decency. But having said that, where does the responsibility come then? Because what Azam Khan did back in 2016 it was in extremely bad taste, and kudos to the man, the father, who actually went on to file a complaint and ask for a CBI investigation outside the state. It did influence the investigation. It did rub a lot of things the wrong way. You can't get away with an unconditional apology. So where is the solution to this? 153.
Okay. I'll just go back to Karan. I think there's some technical error there. Karan, you're back with us. Go ahead.
Yeah. What I'm saying, Rhythm, is that it's high time the responsibility and accountability be fixed. Because when the Attorney General says there is an inherent code of constitutionalism, I'm sorry, we can't be relying on these inherent codes anymore. I agree that the list of 19.2 is exhaustive, but there has to be a punitive punishment. You can't just get away with unconditional apologies by passing such insensitive and careless remarks on a case that was still under investigation. So what I suggest, and I've written time and again about it, is there's high time a commission be formed. The judges can't be judging on scientific matters, archaeological matters, just as we have an archaeological survey, just as we have a forensics department. It's high time we have a cultural team that judges whether there was an intent, deliberate intent to hurt sentiments, and then sections be imposed and cases be prosecuted and reach a final conclusion. Otherwise, ministers can get away with these statements in the name of freedom of speech. Freedom of speech is not absolute. It is subject to reasonable restrictions. But it is this gray area that they continue playing on and continue getting away with one careless remark after another. So it's high time we address that issue also at the core.
Okay, I also want to say that, like you're saying, Justice Nagaratna, in her dissenting view, has also said hate speeches strike at the foundation values of equality, liberty, and fraternity.
Yes.
She's also said that it strikes at the foundation values by making the society unequal, and it should be the duty of every Indian to uphold the dignity of every individual. This is a different perspective that is coming in from Justice Nagaratna, but I also want to say at the same time, the reason I believe, Ashwini, and I come to you now, that the Supreme Court has today said, as this major verdict comes on the freedom of speech and expression of lawmakers, if more restrictions were to be placed on this freedom, whether it's for lawmakers, and I agree with Karan, hate speech is something that needs to be curtailed, a constitutional culture needs to be followed, but if our statute books at this time are redealt with, or would have been redealt with, it would have actually led to more chaos, because there would be more petitions, mischievous ones also, possibly filed, Ashwini.
Rhythm, there are two aspects. Keeping in view the hate speech, or by virtue of a statement made by any public functionary, any constitutional authority, any member of parliament or member of legislative assembly, which attributes or violates the other penal code or penal offenses, then of course that will be the law of the land will follow. Here the question is that whether the restrictions can be imposed on the right to freedom of speech and expression under Article 19(1)(a), excluding restrictions already enumerated under Article 19(2). And if yes, then to what extent? The Supreme Court says, the question was that if there is a public functionary, there is a minister, then there is another extra limitation under Article 92, though it is not remarked there, mentioned there, but they have to be more cautious. And the second thing, what Attorney General argued, that the government cannot be held liable for the statements made by the legislators. So now the question is, if suppose Azam Khan or any other individual makes a statement which is ultimately creating hatred in the society, then of course the section 153(8) will be treated as a hate speech. It will come if it is against the religious, it is against any other person or making any comment on the religious thing, then of course the law of land will follow. But here the question is whether the statement made by somebody, and that under Article 19(1)(a) says that is a freedom of speech and expression, and there is no other law is violated. So, and made by any person who is having the constitutional authority, is this the extra restrictions which has not been expressed in Article 92 shall be attributed or not? The Supreme Court said, look, the freedom of speech and expression 19(1)(a) and 19(2), as is it available to the common citizen of this country, the same is available to the ministers, MPs and MLAs also. Though we live in a constitutional democracy, and suppose there is a hate speech, hatred in the society, there is a rift in the society, then other law will follow.
Yes.
The penal consequences will follow. Yes,
All
over
right,
to
it's
you,
a
Rhythm.
top focus that we'll continue tracking. Thank you, Ashwini Dubey and Karan Verma, for being with us. Major verdict from the Supreme Court on the freedom of speech and expression, where the Supreme Court has said no additional restrictions are needed, but has also reminded public and politicians to have restraint. Public figures must watch what they say. As the story continues through the day, we shall come back to you, Shivangi, in the studio.